You plugged in all the way there, Rich, on the speaker? Yeah. Right. I need to make you. Maybe load in. I'm logged into. Today, the lawsuit is causing a number of changes to a lot of the forms we're using. So today is just going to be just a small aspect of the changes that are forthcoming. So I think there's 40 to 45 different forms that are changed and or added or modified. So we have a lot more to talk about besides just today, as a matter of fact. But I think I actually have some answers now in regards to what takes place with open houses, how you're going to manage that, then also how you're going to be speaking to a potential seller about the residential listing agreement. So the one we're looking at today was modified as recently as 3:45 yesterday or so. And this is, I think, the 10th iteration of the same document. So we'll see minor changes as we go along. But I think for the most part, we probably are seeing basically the language we're going to see. The only change I found in this most recent version is bold print just found at the bottom of section 1. So I want to go through the listing agreement, and I actually want to go through certain aspects of what will take place when you're holding an open house. Because there was a question that we had, what's going to take place if there's no representation? Because the law indicates you can't show property without having a representation agreement. So if you're a listing agent, then you know what are the complexities associated with that. So let's just go through the residential listing agreement as it is going to be right now. So this is very similar, section 1, right, where we're looking at the exclusive listing agreement, not an open listing agreement, and is granting the broker the right to sell the seller's property. So that hasn't changed. And then in bold print, you're going to something, and I don't know if it was in a prior listing agreement or not, but a listing agreement associated with the law change cannot be for more than 24 months. And it's not, you cannot record it. Before, people would go to individuals and say, I'll give you $3,000 or $5,000 and you sign this listing contract because maybe you're elderly, you need the money today. And then when you die, I'm assured of listing that property. So that's something, that's why that is mentioned here. If it's an entity, LLC, corporation, for example, they're not subject to the same guidelines. But I thought I'd mention that to you. But you might even say to somebody, you know, you can see a lot of people listed properties for 24 months. I'm only asking you to list it for 6 months. All right, the law limits us at 24 months. 6 months sounds really short to me. The listing period, I think that's self-explanatory. It's going to begin on a certain date and end on a certain date. The listing price, A2. Once again, whatever the asking price is going to be. And then if the property is a manufactured or mobile home in section B, or a probate or conservatorship, we're going to check the appropriate box. And then, hold on, let me turn this radio off. Sorry about that.
Oh, Carlos, does he have any dummy contracts?
Mike, you can print them out from the car website.
We have dummy contracts. We got much more than that for dummies.
Yeah, because this might change between now and June.
Yeah, I think it's going to be very similar in regards to the language. So yeah, this is all available for us to provide to you. So section C1 4A, compensation to seller's broker. This is only the listing side of the relationship. And you can insert, I think what's interesting, the news has done us a service actually by saying listings are all between 5 and 6%. So if you think about that now, instead of saying, you know, it would have been a 6% listing, you're only going to pay me 3% for listing your home. It's a consideration you should give when you're going through this with your client. Section C2, optional additional compensation, if any, to seller's broker to be offered to buyer's broker. So this is the cooperating broker's compensation. Before, we would take a listing for 5%, offer 2.5% to the cooperating broker. So now section C2 is addressing the amount of compensation you may be offering to the agent who brings the buyer. And keep in mind, none of this can be advertised on the MLS. That is the only restriction. Any other forms of advertising you may wish to use to offer compensation to the cooperating broker is perfectly acceptable. It just can't be on the MLS. Any questions about that? And then C3, additional compensation to seller's broker if buyer is unrepresented. So there may be buyers that come to look at the house who are interested. It's no different than in the past, that don't have an agent representing them. And maybe your presentation to the seller would be, typically a buyer is going to sign a contract for 2.5 or 3% to the agent that's assisting them. And I'm only going to charge you 2% if they're unrepresented. Maybe that's a presentation. I have people in here that are much more experienced than me in listing presentations. But that could be something that may be a reason for you to insert something in there. As if I'm representing the seller and I'm not being compensated for representing the buyer, I'm not going to do it. It's a lot of responsibility and it's a lot more work. Everybody thinks, oh, it's no different in terms of work, but that's just not the case. So you might be saving them money. Section C4, if the same individual agent represents both buyer and seller. Now, it doesn't tell us that we have to fill anything in. It says to the right that total combined compensation shall be C1 plus C2. So I kind of like some of the aspects of the way this form is designed because it's confusing. It doesn't necessarily tell the seller what they're going to be paying. So C1 plus C2, I'm the listing agent. In C2, I've stated that I'm going to offer compensation to the cooperating broker. I could be the cooperating broker, right? So that's what's going to be. And also remember, if you're going to be working with a buyer, you must have a buyer representation agreement signed or some type of representation agreement signed. And from what I've come across so far, there's two. One is it's just like a listing contract. The other one is limited in regards to 29 days. So if I'm a seller, I'm probably going to be looking at this because I myself, and I'm in the industry, had to read this over a few times, really understand what's taking place. It's not necessarily clear to me, and maybe that's beneficial. So under C4 to the right, you don't have to insert anything. But if you want to say the same individual agent represents both buyer and seller, you can say, for example, if I represent both parties, my compensation is going to be 3.5%. Or if I'm offering 2 to the cooperating broker and I'm charging you as a listing agent 3, it's 5. So maybe I'm only going to charge you 4%. This is a variable rate listing. It's no different than what we've witnessed before. So remember, if you have a listing contract and the listing contract changes because you're representing both parties, you're giving some type of reduction in regards to the commission, that's a variable rate commission, and you must disclose that on the MLS because you have an undue advantage over any other agent who's presenting an offer.
So they don't want you to show what you're offering, but they want you to know if it's a variable rate commission?
No, the point is, if you take a listing and the total listing contract, even in this case, is 5%, but if I represent both buyer and seller, you're only going to pay 4% as a seller. That's deemed to be a variable rate listing contract. So you can see I have an undue advantage over any other buyer's agent presenting an offer. And the MLS requirements are such that you must disclose that on the MLS. You must check the box that says variable rate listing. And for those of you that haven't been here before, and we've talked about variable rate listing contracts. So let's assume somebody complains, they file a complaint with the MLS. The MLS is going to request a copy of your listing contract to see if you presented the proper information on the MLS. And if they find that you didn't, I think it's about a $1,500 fine for that. So here's the way to get around that, or to approach it, not say get around it. Take a listing contract. If you're going to do something in which you're going to be offering something less, if I represent both parties, have an addendum to it that's not referenced in the listing contract. We send the listing contract into the MLS and they see that you're fully in compliance. Now, I don't advocate anything that's inappropriate, but maybe this is a way to approach it so you don't get in trouble. Do we have questions about variable rate listing contracts? Somebody does.
You know, this is gonna be,
This is going to be posted publicly. We're going to have to not put this on, post this publicly. I'm here for everybody else, just like you're here for me. That's all that matters to me. And then let's see, we talked about.
So Rich, if someone were to say, like, a listing agent, let's say that the seller agreed to pay the buyer's agent 2.5%.
Huh?
And then the agent doesn't offer the commission, how will anybody know?
I guess it's not going to be on MLS, but
Right.
if you are representing a buyer and you call me, I have to be truthful and honest with you.
But not everybody's like that.
But even then, even if they're not,
Yeah,
the contract is not.
yeah, so,
You as a listing agent, you're not going to benefit anymore because you're only entitled to the amount that the listing agent is specified and agreed to. So that's the other thing. In terms of falsifying that with escrow, that would be a major infraction, I would think.
yeah, because nobody has the listing agreement except for the listing agent and the seller.
They don't unless the MLS requests it.
Okay.
And there's even language in the listing contract that in which the seller is giving authority to provide this listing contract to the multiple listing service if there's a question about it. I would think if I'm the listing agent and someone's calling me and asking me what the compensation is, the most important thing I want to do is sell that house. Now, I know there are those people that maybe are not reputable, but to say that they're not offering compensation and they really are, and you're not going to earn any more money unless you get both buyer and seller. So yeah, that's a good point, Carlos. It could be abused.
Some agents don't want to double end it, and we want to make sure that they double end it. And
It could be abused. And how do you know? Well, that's a good question. The only thing you can do is file a complaint with the MLS, and the MLS will ask for a copy of the listing contract, and you've got 24 hours to provide that. If there's some kind of a question, and they will follow up on that. And then C5, total compensation to brokers. Unless otherwise agreed in writing, seller shall pay broker. So this is interesting. Section A to the right, the amount specified in any is C1 plus C2 if buyers represented. And if the buyer could be represented, the buyer could be represented by both the listing agent or could be represented by the listing agent. So it's almost in a sense a transparent presentation. I'm representing both parties. It's just saying, okay, this is what the compensation is going to be for all the commissions that are paid. The amount specified in C4 if the individual agent represents both sides. So you can actually, if you wanted to accept less than what C1 plus C2 is, you can insert that in C4. Or the amount represented in C1 plus C3 if buyers unrepresented. So it doesn't necessarily tell them exactly what it's going to be. Any questions about that? So you can see everybody has this puzzled look in their faces, and so do I initially. And I can assure you, no seller is really going to understand what that says. Section C6, continuation of, pardon me?
Whenever they are asking for an estimated net sheet, you have to put in information on that.
Actually, it's my belief that both the buyer and seller are going to know what the total compensation is being paid to both the buyer's agent and the seller's agent. Yeah, that's the other aspect I think that's going to be forthcoming. Everyone's going to know what both agents earned.
By the time, because I'm completely new and I've not even got this far in anything yet, by the time you get to actually filling this in, presumably you've already done an estimated closing cost for the people anyway. They've already got something and they have an expectation of what they're going to pay before they actually get to signing the contract. So it's not going to be a complete surprise.
I would say that's less likely. Jay, so when you take a listing contract, do most sellers ask you for what the net proceeds are going to be? So when you take a listing, do the sellers ask you for what the net proceeds are going to be before they sign a listing contract? What do you typically experience? No, you know.
I just to say, you know.
Yeah.
Paying with detail, paying on a decision.
Yeah, if they know. So most aren't even thinking about that. But I think that's part of your presentation though, because sometimes they focus on what the gross selling price is as opposed to what they're netting. And you may have a discussion with them that, okay, what do you really want? What is it you need the money for? What's your purpose? So that's a different way of looking at it too, when you're having that discussion. Section C6, this is the protection clause. So if I've had buyers that have visited the property or I've had offers received before the expiration of the listing contract, if I submit a list of those buyers' names, not the agent's names, to the seller and they buy within the number of days I've inserted in there, if I insert 90 calendar days after the listing period or an extension, then I'm protected for up to 90 days. So this is really no different than the former listing contract. It just presented differently. Same thing with C7, seller obligation to pay previous brokers. Now it's possible that a prior broker had listed the property and maybe they gave the names of all the buyers that visited the property during the time that their listing occurred, or they had offers. So the seller has an obligation to disclose that to you. And this is no different than before. Yes.
So based on that, would mention that they have the time of their lease and then of those buyers.
Yes. Yes.
And you know, if it's any fee, then there are 90 days for that 90 days that you mentioned. You know, sometimes a buyer might go see the house and they don't have an agent, but later on, if they sign a contract with another agent, then what?
If they sign a contract with another agent, well,
Yeah.
because you've given them a list of buyers' names, if they sign a contract with another agent, you're still entitled to the compensation.
But they didn't know that already their name is part of this.
It's not up to them to know, it's up to the seller to know that, because it's a seller that owes the compensation. And the seller, theoretically, because the seller's notified the subsequent listing agent that these names are on the list, if any of those people buy the property, the listing agent, the current listing agent, will not be entitled to any compensation, nor will the current listing agent have an obligation to represent the seller during that transaction. So out of the seller's pocket, it's no different, assuming they notify the subsequent listing agent. Sure.
Now, is this just for any buyers that you showed the property to, or just any?
Any
offer?
buyers that came through the
Purchase.
property, anyway, whether they're represented by another buyer's agent or not. So
Whether
if
they
you get
submitted
the
an offer
names,
or not?
whether you get, right, whether they submit an offer or not. So keep in mind, I think there's another benefit that's coming out of all this, because the other documents we're going to talk about today are sign-in forms that are now mandatory if somebody's going to look at an open house. And I think that's really important for a listing agent, as a matter of fact. So the sign-in forms, you're not going to let somebody in unless they sign some type of non-agency agreement, and we're going to talk about that today also. And the form that I'm going to suggest using would also require that they respond to whether or not they have a buyer representation agreement signed currently with another agent. Let's see, and then section D, optional seller concessions. Seller authorizes broker to put in the MLS that seller is willing to consider offers asking for concessions with an amount equal to. What can this be used? This can be used for anything. So if I'm a seller, as opposed to, this is something I can actually advertise in the MLS. I can say I'm offering a $20,000 concession to a buyer. You cannot in any way reference commissions. That's a violation. And my guess is the fines, the fine structure is going to be dramatically revised, because if somebody does put that in the MLS, that's a violation of the suit, which is associated with antitrust. So my guess is that's going to be a substantial fine if you post anything in the MLS that suggests this concession can be used for compensation.
But it can be used.
It can be used for compensation, any of the buyer's closing costs. So it's very broad in regards to what you can use it for. Just don't specify commissions.
You say seller concession available if you bought an offer by next date.
You might be able to do that, because, you know, the argument I would have against that, and I don't know, I really don't know the answer to that. If you're an agent and you offer an incentive to another agent that if you close the escrow by May 31st, you're going to earn an additional $5,000. That's a violation. But from a seller offering a buyer an incentive, that might be permitted. Yeah.
So if we sign a contract right now, so it should be the end date, the end of this month, May, because this is it would be in effect for June.
No, maybe I'm just missing the question. So if we sign a contract now to buy the property,
To sell them,
to sell the property, okay, we sign a contract now,
sell the property.
and if we give the buyer an incentive if they close escrow by the end of the month, is that what you're suggesting? That very well may be acceptable.
So
You can
that's
offer an
what-
incentive. You close by the end, you make an offer and you close by the end of the month. Now, remember, just because you put that in the MLS, unless that's characterized in the purchase contract, it's not enforceable. So keep that in mind when you're structuring a purchase contract or a seller's offering that. So anything that's in the MLS, if it's not on that contract, it's not enforceable. But yes, I think you could do that. Yeah, that makes sense to me. So concessions, if the seller wants to offer a concession, then it's probably easier just to say, hey, you should probably offer something to the broker that's going to bring a buyer. Because I can't imagine, and I don't know if anyone's going to refute this, but if I have a buyer and I'm going to show a property, I think I'm going to ask the listing agent, what is the compensation that's being offered, if any? Sarah, would you take a buyer to a property without asking that question? So would you take a buyer to a property without knowing what the compensation is being offered? No, not now, but in the future, because nothing's gonna be on the MLS. Before, we never really that terribly concerned about it. Yeah, I think you're gonna call the listing agent and say, what is it you're offering, if anything? Right. We had a previous discussion about lenders not allowing, in certain cases, buyers to pay agents commissions. So Fannie Mae, Freddie Mac, conventional loans, the buyer will be able to pay commissions. FHA, supposedly they're leaning in favor of allowing buyers to pay commissions, VA loans or VA borrowers. Currently cannot, so I don't know if that's going to change. That's a real disservice.
Does that mean it's going to be included into the loan amount?
It could be, but if you're a buyer, if you're an FHA, that's still questionable. VA, definitely you can't pay for the buyer's commission, the buyer's agent's commissions. You're gonna have to offer more and have the seller pay those commissions. That's the only way to structure it.
We have a question from Ella. For a listing agent holding an open house, then does he or she ask the potential buyer for a copy of their buyer's agreement if they claim they already have one?
Well, I think that's an excellent question, Ella, and I'm gonna get to that today. So I'm gonna save that till we get to the CAR forms that have been created for us. And then section, any other questions before I move on?
That was it.
Okay. E1, items included. If the buyer or the seller wants to include certain items in the sale of the house, they can put it here. But if we read through the body of this residential listing agreement, it specifically states that if it's not in the purchase contract, then it's not going to be included. Sometimes people don't want to take certain things, and sometimes buyers don't want the sellers to leave certain things. So excluded items. And then E3, lease items, propane tanks, solar, which is very common right now. In the body of the contract, it tells us that within 3 days after signing the listing contract, the seller must provide that documentation for us in regards to any encumbrances that a subsequent buyer is going to be assuming. I think that's a good idea. Lien items. So same thing as leased items, in my opinion. There's an encumbrance against it. It could be something that's against title. It could be a UCC filing for a personal property. And then smart home features, the seller prefers to include or exclude. And then F1 property will be marketed in the following MLS. Ours is Sierra MLS. And the reason it's asking this, because it could be an out of area listing agent, and it could be the Big Bear MLS, of which they're a member of. So in the body of the listing contract, it's putting the seller on notice. You may not get the most exposure. So it's giving them some idea, if you want to say that. F2, coming soon status, and this is really no different than the current residential listing agreement. So the coming soon status, the default response is that coming soon status is available. But remember, if you're going to use a coming soon status, you're to use a coming soon form. And I can't remember instructions to put mark or property coming soon. I forgot the entire title of it. But so the default is you can put a property in coming soon status, but you still must have that other addendum to the listing contract signed in which the buyer, excuse me, the seller is giving you permission to put in coming soon status. And it's also talking about days on market. Remember, if it's in coming soon status, no days on market accrue on the MLS. So that's the advantage. You cannot show the property during coming soon status. If you do, I believe you have 1 business day after showing the property to make it active on the MLS. And the coming soon status cannot last for more than 21 days.
And if you market it as coming soon, you have to have the date on there.
The
when
date,
it's
you're
gonna be
right, good point. So when you market a property as coming soon, don't just say coming soon in your advertisement. That's a violation. You must have the date that it's going to be active. And a listing contract should actually tell you what that start marketing date is or that active date is.
And the for sale sign must have the coming soon above it as well, right? Along with the date.
Right, it has to, if you have a for sale sign on the front of the property and it says coming soon, you must have the date that it's going active. You want to avoid a fine.
Can I ask you a question?
Yes.
What if unbeknownst to you, the seller actually takes someone and shows the house?
Without putting it on a coming soon status, and I saw this thing recently, and they're gonna start showing in October.
Yeah,
So, they mentioned that there will be no showing.
it's a violation. It's a
Yeah.
monetary violation.
Unless there's some buyer put an offer on. So,
Well, if they're refusing to show the property and it's in an active status, that is a clear violation. Click on file an anonymous complaint. Is this wrong? They're just trying to double in the property.
So what is the benefit for them when they do that?
They want a buyer to come to them directly. Because it's gonna, if it's active, it's gonna be disseminated to all these different third-party portals, including Zillow, Redfin. So buyers are going to see it.
But it's, it's like that it was showing that they won't show the property until this coming weekend, which is Saturday.
Uh-huh.
But the client, and when I told the client that, the buyer said, no, that's so weird, because on Zillow, even they scheduled the 2 for today for.
Oh, yeah, they're lying. If you want to do something like that, don't type it out in the MLS. When an agent calls you to show the property, just say, I'll contact my seller and make arrangements, and I'll call you back. And magically, your seller is not available to allow the property to be shown. But if you put it in the MLS in written form, it's a violation. You're violating the clear cooperation policy. Yeah. And it's at least a $500 fine.
Ella's asking, what if the seller shows the coming soon house without the listing agent's knowledge?
Well, I would say the listing agent's at risk. That's what I would say. If anyone goes into that house, it's always going to be the listing agent who's at risk, because it's going to be your fellow agent who's going to report you to allowing somebody into that house. And how are you going to contact the seller to begin with unless you knock on the door? You're not going to have the seller's contact information unless for some reason the listing agent puts in the seller's contact information into the MLS. All right. Anything else about coming soon status?
is it, so, a violence if tenants are not cooperating?
That's a different story. Yeah, that's a problem between the property owner and the tenant. So yeah, I would say that would not be if the tenant's refusing access to the property.
Plus you might have to schedule a time that they're available to show.
Yeah, it's always more difficult with a tenant occupied property. Public marketing. So let's assume the beginning date is today. And what's the date today? The 6th, 7th? 7th, thank you. But we don't want to start showing the property until June 1st. Then we would insert the date for public marketing in June 1st year. And then let's assume for some reason I put my sign up before then. Well, that's public marketing. And within 1 business day, you need to change the status to active. And it's going to be your fellow agents that are going to report you. So any public marketing. So, and then the other aspect that's interesting about public marketing, well, what if the seller themselves starts posting things on Facebook? Well, I would think that you're going to be at risk also. Any public marketing. What public marketing does not include would be if I'm an agent and I have a client and I have an agency disclosure signed with that person. That's not a contractual obligation, it's just an agency disclosure. So that's not considered public marketing if I contact that person. Also, if it's under the same brokerage's license number, dissemination among the agents associated with that individual broker's license is not deemed to be public marketing.
But I've done before in the past, it's like I have a video that I put up, like, oh, this home is coming in the market soon and we're getting it at the staging with short video. I don't, is that not allowed?
It's not. No one's reported you. Everybody likes you, Shweta. That's okay. So now that everybody here knows, nobody here would report you.
Can I ask one question or two?
And then the clear cooperation policy, the default is that we are subject to the clear cooperation policy, and we are. And the clear cooperation policy is such that within 1 business day of marketing a property, you must put it on the MLS. And it doesn't matter who's marketing that property. So even if the seller gives you written instructions to keep it off the market, and you do anything beyond disclosing it to a client you have that has an agency disclosure, or it's disseminated among the individuals associated with a specific broker's license, that is considered public marketing. And then listing features kept off the internet. This is no different. I don't know why any seller would want their address and things like that not included.
Question is the coming soon per each MLS board, or does it cover all the MLSs?
I don't know. I would say it's the MLS. So CRMLS has adopted a clear cooperation policy together with coming soon. So if it's a different MLS, I cannot tell you categorically they're adhering to the same rules. But CRMLS covers such a wide area. It's rare that we're not included in it, as a matter of fact. And then let's see, G1, time of your presentation of offers. Well, it seems common, I guess, if the seller doesn't want offers presented immediately, they can tell you to do that. Buyer supplemental offer letters, so-called love letters. Right now, the instructions, the default is such that the seller is instructing the listing agent to not present any love letters. And I think the reason to not even engage in that, and the listing contract and the body says the agent will not even read those letters. If it's a protected class and somebody makes a decision, even improperly or non-improperly, it could be discriminatory. So I would always dissuade somebody from asking for personal letters from the buyer who's making an offer.
Sometimes on the body of the email, they kind of type out a little bit of background about their client and whatever.
Mhm.
Send you the offer, and you just forward the offer, you know. You forward the email, which has it.
Well, I would agree with you, but if right now at this listing contract, if you arbitrarily just forward everything, including that, you're violating your contractual obligation to the seller, because they've instructed you to not send them. I'll just mention that. And then investigation reports. So this is really no different than former listing contract. Right now, it's saying that the seller shall order and pay for any reports that are checked, and the default is the natural hazard disclosure report. Oddly enough, it was the same in the prior listing contract, but it really wasn't noticeable. So they may say, why do I have to order that report right away? Well, it was always that way. Not that that's a good answer, right? But you're going to have to order it anyways. That's why. And no escrow in my, oh shoot, has ever ordered that report until we have escrow opened and we have notified all the parties. So I wouldn't be too terribly concerned about that. And then H1, seller instructs broker not to take or use photographs in marketing except as required by MLS rules. And then H2, MLS instructions. There are sellers that don't want people taking photographs. So if they don't, and you check the box under H2 to the right, then you must put a disclaimer in the MLS stating the seller doesn't want any photographs taken by anybody other than appraisers and inspectors. But that doesn't mean that you have to rip somebody's cell phone out of their hands either if they're in the house taking pictures. That's not your obligation. Yeah. That's what the sellers are going to expect. Exceptions to ownership title. Well, maybe there's 3 parties that own this property and only 2 are signing this, or I need somebody else to sign the grant deed. So it's going to be rare. We might see something like that, but it's possible. And then section J, seller intends to include a contingency to purchase or replace her property as part of any transaction. So the seller saying, I'm not selling my property until I find a replacement property. But remember, this is fine, but if the purchase contract, the accepted contract doesn't specify this contingency, then it's not a part of the transaction. And then the default is for K, owner opt-outs, key safe lock boxes. You're permitted to put them on the property. Signs, you're permitted unless you check the box, so don't check the box. Any additional terms? So let's just see, let's just go through here to see if there's anything that I kind of missed, or do we have any questions at this point in time?
No, there's no question.
Okay, all right. I think most of the items we have talked about. Section 5, seller concessions, we did talk about this. It specifies that any of the concessions offered cannot be identified as associated with commissions or compensation. What's that?
Can seller concession be advertised on Zillow or no?
Yep. But Zillow is just an IDX site, just like our website. So unless you have,
Section, does it go under compensation or does it go in the body of the email, body of the?
well, that's a good, I think if you have a Zillow account, can't you advertise your own information? Okay. But if it's just something, you put it on the MLS and it's being disseminated through IDX websites, just like every other office gets. I don't know how you would do that, but you can. Now, what I haven't come across anything at this point in time would be, there's a section, the public remarks, you cannot add anything about compensation in there. But what is the other term? The distribution of all this other information, which can include the syndication remarks. My thinking is in the syndication remarks, I don't know this for sure, you might be able to specify what the compensation is, because it's not a matter of the public information on the MLS. Syndication remarks are not distributed to the MLS.
The body of the description that says on top and versus at the bottom, because the bottom is the one that's indicated.
Well, I think it's a second page when adding a listing, it has syndication remarks.
Yeah, it's on the same page, but the
It's on the
description
same
MLS
page?
top and then the
Okay,
syndications on
yes,
top.
Carlos is confirming that you're right. Yes, yes.
Sorry.
Yeah.
You probably mentioned that, but for those active listing that, they have it like that, it would expire like 2-3 months from now. But the law is in effect from next month, right?
Well, what's happening right now, the implementation of the form changes is assumed to be the week of June 25th. Now, is the MLS going to comply with that same time frame? I'm guessing they will, but right now, from what I read with the lawsuit, the actual settlement won't be signed until November of this year. So it may not be signed, but what I envision is that we're going to be ahead of the settlement being signed. So that's what I would expect, yeah. Section 8, this is nothing new. Benefits of using the MLS versus not. If the buyer wants to opt out of information being disseminated via the internet, they can initial here. We talked about the clear cooperation policy. All right, you must put a property on the MLS within 1 day of actively marketing it. And then representations of the seller, I have authority to sell the property. Presentation of offers, we talked about that. Talked about buyer supplemental letters. But I want to get to these other forms because the dilemma we're going to have right now, which I wasn't sure of at least. What takes place when you're holding an open house? So there's a couple of different forms that have been created. And the first form is not one that I prefer, but I just wanted to go over it with you. Open house visitor non-agency disclosure and sign in. So now when you have an open house, you're going to have every buyer sign a document. Now they're going to be nervous. That's
names,
yeah.
right?
Names and at least email address. And there's something to be said about that because you'll be getting the email address and you might just insist on that.
Or a fake name if they.
Or a fake name, they can do that.
That's what they do now.
Yeah, if they give a fake name, they're probably not a real buyer, right? So this is interesting. Yeah, I can't wait to see how we all manage this. But visitor intention to view property. So we're going to have the basic information filled in, real estate agents, the brokerage. You might have that pre-printed, so you have a number of these with you at an open house.
Can you ask them for their ID?
Refuse. What do you do? Say, well, I'm sorry, you can't.
You can. I wouldn't let them in. Easy for me to sit here and say in front of a bunch of realtors,
Yeah.
right?
Can you ask for their ID, Rich?
Hmm?
Can you ask for their ID?
That's
Confirm
not
that-
saying that. I don't think I would be asking for an ID.
Make sure that at least their names. So that
I don't
way-
think I'd be asking for an ID. I think we take them at their word at this point in time. So that's a good question. If you're the one who allows somebody in without getting them to consent to something like this, or the other form, it asks them specifically if they've signed a representation agreement. This form does not. Then you're the one who could be at risk. And you're violating the law. It's not just a fine.
It's the law.
And yes, and you can bet that they're going to make an example of somebody doing this. That's what happens typically when there's a violation of law. I'm going to make an example so everybody else lives in fear that it's going to happen to them.
So what is this form about again?
This form is going to be if you're holding an open house and a buyer or visitor wants to come in to view the property.
So they have to sign.
You as the agent holding the open house are required to have one of these following documents signed.
So this is a new law.
This is part of the settlement. Yes.
So if someone is not willing to sign, then they cannot, because it's a law.
I think that's going to be your decision. Are you willing to take the risk to allow somebody to view the property without giving you or acknowledging that you are not representing them? And what this form is saying is that I don't represent you. We don't have an agency relationship. Anything I do is simply on behalf of the seller. As you can't show a property under the new guidelines, you can't take a client to a property without having a representation agreement signed. So if you don't have a non-agency document signed, that means theoretically, you may have an agency relationship, and without that document in writing, then you may be in violation of the law.
So this would eliminate for those agents that are already working with somebody and the buyer goes and say that you can come directly to me and I'll give some discount.
I think so, but more importantly, the next one I'm going to show you, it's more information actually that's provided to the person that wants to view the open house. And this form does not have the question, have you currently signed a representation agreement? I think it's far different asking somebody as opposed to them signing something saying, I do or do not have a signed representation agreement. So very well could be for your benefit to use the next form we're going to go through. But I think it's going to be a decision you're going to have to make when holding an open house, which is going to be more beneficial because the longer the form, people are going to be nervous walking in and thinking, I'm going to have to sign a document to look at an open house.
What if they come with their realtor?
Then that's fine. I think you can presume that they have an agency relationship. I don't think I would be in the position of questioning them. If that agent is willing to show the property without an agency relationship, without a representation agreement, they're the ones in violation of the law. So this is just really complicating already what is a complicated job.
But like we talked about earlier, that even when you're gonna test drive a car, they want your driver's license and they want proof of insurance before you can even get in the car.
But that's a good point that Carlos brought out to me. He said, you test drive a car, they want all your information, your insurance, your driver's license. I think that's a great response. Well, you can't test drive a car, which is maybe a tenth of the cost at best, or a 20th of the cost at best, as opposed to coming into someone's house.
You're not going to drive the house into somebody else's house. Are you?
No, you're not.
But
You're
you're
not.
walking into somebody else's house. you
Yeah.
know?
Most people, no sellers want people walking through their homes. But unfortunately, it's going to be changed, not just for us, for every potential client out there too. So it's just something to give consideration to. So you can see in the form that the visitor wants to view the property. Agent does not represent visitors, so it talks about that. And communication with the agent at an open house, it's telling them anything you tell me can be used against you. I can tell my seller anything that you tell me, because we don't have an agency relationship, right? And then if visitor writes an offer on the property through agent, at that time, agent will disclose if agent and agent's broker represent the seller exclusively or both the seller and the visitor. There could be an agent who's holding that house open, it's not their listing. But if that agent works for under the same brokerage license, then it is dual agency. So you'd have to, after they sign a representation agreement, or after they would be notified. And then also, a visitor wants to be represented by the agent holding the open house. It says they should sign a representation agreement. And there's what I'm aware of currently, 2 representation agreements, a limited one, we'll go over that, and then the BRBC, buyer representation broker compensation agreement, which is similar to a listing contract. So I don't prefer this form. Now you can actually, but this form does have, it's interesting, many signature blocks as people walk in. You can have them sign this. At least you're protected. That's important. And then the next derivation of the same form is the open house visitor non-agency disclosure. And there are many similarities through item 3, then item 4. Possible visitor representation by agent. If visitor wants representation by agent, visitor needs to sign a separate agreement such as an open house, property tour limited, property representation and broker compensation agreement, which is form LPRBC, or a buyer representation and brokerage compensation agreement. So the LPRBC is a limited representation agreement. It certainly covers specifically the property that you're showing, although I have questions about a term in there that I'll share with you. But you can also specify other properties. So you can have a limited representation agreement saying, you only pay me if you buy this house, or if you want to specify additional properties on that form, then you can do that because you may show them other properties. So this is the next step above the form before. Now, people may get nervous about signing something like this because they're going to be sitting at the front of the house thinking, oh my God, for me to see this house, I have to sign what I think might be a contract, but it's not. If they sign this form, it is not committing them to anything, which is very interesting.
Is there any
What
part
happened?
that,
Sorry, what now? Didn't you hear you?
It's just-
Why the form? Because it's required by law, right? Because you're specifying non-agency, but you're also giving them the option if they wish to choose you. Well, that's great, but I have to have a signed representation agreement with you. And we can do that, and we can sign that agreement, and you're not committed to me beyond anything else besides this house. So you can do that as a person showing the property. Your commitment is only to me for this house. Maybe that makes them feel better. I think as we talk about strategies when you're trying to get people to sign buyer representation agreements, do you tell them, I'll only hold you up for a day, I'll hold you for 30 days, and either party can cancel? What's going to be your strategy when getting buyers to sign these representation agreements? Is if they don't know you, they may not have any confidence in you in any way whatsoever, and you may have to prove that to them. It's great to get at least a 6 or 12-month representation agreement signed, but maybe they'll be hesitant doing that until they know more about you. You're going to say?
Is there any part in the form that protects their information to be shared with other people?
In this form, well, this form gives you the right to share any information that visitor tells you. You can share that with the seller. Is at this point, you don't have any type of agency relationship with that buyer. And it's also telling them that you can submit an offer through me. That's fine. But if you do, you're going to have to sign at least one of these two documents in which we have a relationship, an agency relationship, and in which we're also addressing how much you're going to pay me. So this form, unlike the other form, the initial form we talked about, and this in the box, if applicable, visitor already has another broker. And that's why I tend to like this form more. At least I know categorically they're telling me that they do or do not have a representation agreement. They don't check the box. Well, that could be your client.
Ruth is asking,
Please check the box even if they don't have one.
If they could, right?
but they still have to sign in, right?
You have to sign this form. So yeah, they could lie. I don't know. Do you think most people are going to lie about that?
Yeah.
Okay, well, there you go. They're going to lie about it. Have you had that type of experience where somebody lies about having a representation agreement signed?
Yeah.
Oh, well, okay.
I mean, it's not gonna matter whether they check the box or not, they still have to sign in.
They still have to sign in. They have to sign in,
And
but
that's-
but I'm hoping to find some truth here that,
Yeah.
whether they do or do not, right? Yes, they do. They actually have to, so that's a good point that you brought up, Steve. The difference is they have to insert the name of the brokerage. So maybe the percentage of lies will diminish. Bless you.
Ruth is asking if you can explain the difference between the buyer representation and just an agency. disclosure.
An agency disclosure simply, there is no contractual relationship, and it talks about the fiduciary obligation if you are working with that buyer or with that seller. Whereas the buyer representation agreement, it's a contractual obligation between you and the buyer for maybe a stated period of time in which, and if it's an exclusive agreement, you as the buyer's agent are entitled to compensation no matter who represents that buyer for a purchase.
You know, when you're looking at this form, it makes it easier to get a buyer agreement.
Absolutely.
Because you say, if you don't do it with me, you have to, every house that you go, you have to sign that.
That's a good point. You're going to have to do that with each and every one. Do you want to do that? Probably not.
It's gonna ruin everybody's weekend hobby.
Well, maybe we'll only have serious buyers, right? Yeah,
do
this
a-
isn't making anything easier. So the next document we're looking at, the limited property representation and broker compensation agreement, is a limited representation agreement. And it's one of the two referenced in the prior document, as a matter of fact. So let's assume we have somebody and they're interested in having us represent them. It tells them, first of all, they don't have to sign to see an open house. They don't have to sign a representation agreement. Yeah.
Carmen's is asking, what if the visitor requests a copy of the document? And keep in mind,
Tell them to take a picture.
that's.
You know
that's
what?
good enough?
Give your phone number and I'll send you a picture of it.
Okay.
So,
Yeah, because I was gonna say, they can't have a copy, it's got other people's names on it. But just the top portion of it, right?
yeah, just the top portion. That's a good point. If they want a copy of it, that's fine. You just have to truncate that. Give me your phone number. I'll send it to you. Yeah, you may not want to allow them. It's a good point, giving someone else's contact information out. But those are all things that no one ever thought of, Carlos, in the real world, right? Until it actually happens. You could be blamed for giving out someone else's contact information. I never thought of that. And so in section 1A talks about you're not required to sign a representation agreement to see the property, but you must sign one of those other forms. Okay. Otherwise, I'm to find a listing agent. I let you in. I'm violating the law. And then if you have a representation agreement, you should inform the agent. And then it also says in 3, if you don't want the agent holding the open house to represent, you don't sign the form. And this is where I find this odd. If we look at the very top of section 1, broker right to represent visitor. Visitor grants broker the non-exclusive right to represent visitor. However, there's language in page 2 that it's opposite to this and saying you will owe me compensation if you buy this house. But this says non-exclusive, which I don't understand. It should say exclusive. But anyways, there's language in there obligating the buyer. And then for section B. So let's compare this to the buyer representation broker compensation agreement, the VRBC, which is the full representation agreement. If we look at section B, we can just simply obligate the buyer to just specific properties if we want. So anything else they see, they have no obligation to us. Does that make that more palatable to them when they first know you? Maybe. Maybe once they get to know you, then you have them sign the entire BRBC, or they're just obligated to you for a period of time. Remember that the BRBC, it can be exclusive, it can be non-exclusive, so they can work with multiple people. It can be for a certain time frame. You can also give everybody the opportunity to give a notification and cancel. So it depends how you design that. But that form has changed dramatically, and we don't have enough time. It's already almost 11 o'clock to go through that. So with this limited representation agreement, you can see section 2A, beginning on the date signed below and ending not to exceed 30 days. So it's limited. And then the amount of compensation, section B1, the percent of the acquisition price. So if we want 2.5, we want 3%, we're going to insert that there. Section B2, payment from third parties. If the seller offers compensation to offset the 3% we put in there as our fee, then they get a credit equal to that amount. And then other terms. Now this form actually gives either party the right to cancel upon a written notice. And it doesn't state that there is a requirement in regards to what that written notice is, which I found very interesting. Under section 4, cancellation of representation agreement. Either visitor or broker may cancel this agreement by giving written notice. So if during the time before cancellation, you show them a property or submit an offer, or for those properties listed, you're protected. But either party can just send out a cancellation. And I don't think that's appropriate myself, but that's.
Then the buyer representation agreement anyways, where either party can cancel.
You can structure it that way, or you can say neither party can cancel also. So it depends how you structure it. Whereas this one, it just gives each party the right to cancel without even any notice. I don't know if anyone's going to read it. So that is, and then the BCA, which is associated with the residential listing agreement, talks about broker compensation, so on and so forth. It's a disclosure, nothing more than that. Just puts them on notice. But that's what I see happening right now. And as I said before, I think the most critical thing, you're holding open houses, you're speaking to buyers in regards to signing a representation agreement. What's going to be your strategy? How long do you want to lock them into a contract? And if they're really concerned, do you use something like the LP, I can't remember it even, LP RBC, in which they have limited obligations to you? I'm not sure what the right answer is at this moment.
Kim's asking, will the buyer's agent need to provide the listing agent for all showings, like their agency or their buyer agreement before showing them?
No, I think we just rely on their representation. And we want it in writing. That's really what it's coming down to. So we need to just, if we have nothing, the only way to protect yourself is use one of those 2 initial forms in which you decline or you're stating you do not have an agency relationship. Then the second form, not only are you stating you don't have an agency relationship, but then they're telling you whether they do or do not have a buyer representation
I
agreement.
think she was asking though, if an agent shows the property, do they need to provide you a copy?
No.
With a copy? Okay.
I would just, as I said, someone asked the same question. If they're showing a property without a representation agreement, they're violating the law. So that's their risk to do something like that. I don't think you have any obligation to police them in that regard. Any questions?
Not a question, but a comment. It just seems to me that the opportunity is that once somebody who's seriously looking has to go through this 2 or 3 times in different houses, they're going to go to hell with this. I need to get an agent to look.
Could be.
I agree with you.
Like a pre-approval letter.
Yeah, it's work. Right? I just don't walk into an open house. I agree with you. And someone else who said that also said, do you want to go through this over and over? You're going to have to sign these documents. Do you really know what you're signing? Let's just sit down and talk about how we can move forward so you are protected and we can best represent you. And everyone's going to have a different approach. If whatever the compensation is you're putting in these forms, my approach would be at least to say, and any seller concessions, we can use to offset my compensation. And then if there is compensation offered by the seller, that will also it will offset the compensation that you're going to owe me. But I'm not going to work for free.
These forms are making it real for all buyers to put them on notice that you have to sign with somebody.
You have to sign with somebody. You have to. Yeah.
So is this in effect from what?
The release date is the week of June 25th. So I'm expecting, because the release date's happening approximately then, that's going to be our obligation, because I can only assume the rules and regulations are going to change to reflect this as our obligation. And then the settlement, ultimately November, who knows, December, it's always getting pushed back, but obviously we're not waiting.
No, but what I mean regarding this particular form is that from July, they need to sign this, or from November?
I believe it's going to be June, or the beginning of July. That's my point. The rules and regulations of the MLS are going to change to reflect the requirement that we do this, even though that settlement agreement isn't signed.
Yeah, because this is car. So
Yes, yeah, this is car right now.
this would be from June,
Yes,
but MLS would be from November.
the same thing. It's all the same. So the nationwide settlement won't become, in a sense, law. It's case law because it's been cited in the courts until that point in time. So at this point in time, it may be only a violation of the rules and regulations. However, once that settlement is signed, it's going to be a violation of law. That's what I envision.
So which form do you recommend that we use for an open house, that we have them sitting there for them to sign?
Well, if I have multiple parties coming through, it's going to be tough.
Maybe print out different ones?
You could, at minimum, right now, this would be the minimum form we would use, where it's easier for people to sign in and less verbiage for them to read. But you can also just, in this open house visitor non-agency disclosure, print out multiple forms, make sure your company name and your name is in there, and hand it to each of them. I prefer this because it's just, as you said, I'm not giving anyone else information, contact information for anyone else that's signed in. But is this more overwhelming to a buyer? Yeah. That's it.
How long do you have to hold on to these after you've had them signed?
You want me to, like an agent, representing buyer or existing agent? How do we know, since this has been loosely like passing around, everybody signing this? How do we know that buyers actually cancel the previous agreement or anything like that before we go forward? God knows how many.
Well, that's, if they don't know and you've asked them, you're not in violation of anything. And if they're that dumb, they're going to be obligated to pay 2 commissions.
Well, I know they're dumb.
Well, there you go. Well, that's if they're that dumb, they probably don't have enough money to buy a house anyway. So it's it.
So
That's
Richard,
just speculation on my behalf, but if they don't, I think everyone's gonna become much more in tune as time goes on.
I think this is a better form to use because here they have to specify whether they are working for another agent or not, whereas the first form, they don't have to specify anything.
So everyone has their opinion regards to how they're gonna do it. And you've had open houses, which you've had multiple parties coming through and you're overwhelmed too. So it's difficult.
Now it's be like, here you go, sign,
Sign, and give me your email address, otherwise you don't come in.
so if
Which
you're
is
gonna
something
do,
really interesting. That goes back to COVID, right? We actually got people's contact information. So your time might be a lot more productive at an open house actually now. They may lie, right? But, and if they do, just as long as you're complying, that's all that matters. This is my practice, right? I always have everybody sign it if somebody were to complain or suggest you don't do that. And here's evidence of the standard practice I have. Oh, one other thing that's in a listing contract, by the way, I don't know why I thought about it, but I'm sure it's been in the past listing contract. Everybody has cameras in their houses now, so sellers have an obligation to put people that tour the property, visitors, let's use that term, on notice. Yeah, it was. I just want to remind everybody of that. I think we take it for granted now. Being filmed.
Kimberly's asking, how long do you need to hold on to them for? Just a day or how long?
Well, we have an obligation to keep documents for at least 3 years. 3 years. So that's a good point. Because us collecting that information, that's a good point. Let's see.
so if you're gonna do a tour to show 5 properties,
Well, I would say that's up to you as a listing agent. You don't give me your email address. How do I know you're a real person? And I'm not in compliance with the law. I don't know if the email address is necessary according to the guidelines, but it certainly suggests that you should get it. It's a personal decision. I don't want to give my email address. Okay.
I don't need that.
I wouldn't want to either. I think when anyone's holding open houses, do people usually straight up? Do they refuse to give you that if you ask them?
Sometimes do, and I'm like, yeah, well, just put in whatever you want with the people's form.
Okay. Okay, and they usually comply with that? They put something in there?
Put some lunch.
Okay. Yeah. All
You
right.
know, sometimes the family will come to see their open house.
Yeah.
And they say, why don't you give your information, one of them?
Uh-huh.
So, and then somebody else buy a house.
Well, the representation agreement covers you for that. It talks about anyone related or an entity related to that individual. So yeah, just have to chase them. Right. Any other questions? No. All right. Well, thank you, everybody. Thanks for coming today. I appreciate it. Oh, we have a drawing. Hey,
For those. that come in.
fantastic. For those that are here, right?
So we have a couple pairs of movie tickets. So, Rich, do you want to draw a few? Then that way, if you don't win, you.
Now
can get
have
mad at
Rima
Rich.
do it. She looks innocent.
No, we'll let. You want to draw two? Okay, don't look. Oh, she drew her own. Sarah Park. And then you gotta draw one more. Data.
Nice.
So there you go.